everyone, and welcome to our segment entitled Legal Matter, Lamang ang May Alam. Firstly, I'd like to introduce myself. My name is Michael Hermano, and I will be your facilitator for today. And together with me are my group mates from the Rizal Memorial College's School of Law. Next slide, please. So we have Ms. Charry Daplin, Mr. Ricardo Musa Jr., Ms. Jonica Eva Tagupa, Ms. Sonia Santos, Mr. Grego Centillas, Ms. Edelyn Derecho, Mr. Marquin Sullano, Ms. Calceta, Ms. Melca Tapare, Ms. Mercy Grace Magno, and Ms. Maria Anny Yanong. So today we will be discussing the case of Conrado M. the complainant, versus Attorney Anastasio Revilla Jr., the respondent, administrative case number 7054, promulgated on November 11, 2014. But first, let me start with the definition of the written statement of the practice of law. So the basic inquiry in a petition for reinstatement to the practice of law is whether the lawyer has sufficiently rehabilitated himself or herself in conduct and character. The lawyer has to demonstrate and prove by clear and convincing evidence that he or she is again worthy of membership in the bar. The court will take into consideration his or her character and standing prior to the disbarment, the nature and character of the charges or charge for which the lawyer was disbarred, his or her conduct subsequent to the disbarment, and the time that he or she was disbarred, and the time that has elapsed in between the disbarment and the application for reinstatement. So now here are the statement of the facts that will be discussed to us by my group mates. So Ms. Daplin.
Thank you, Michael. Okay, in this case, the facts are the following. Attorney Anastasio A. Revilla Jr. was disbarred by the court from the practice of law on the following grounds: abuse of court procedures and processes, filing of multiple actions and forum shopping, willful, intentional, and deliberate resort to falsehood and deception before the courts, maligning the name of his fellow lawyer, and fraudulent and unauthorized appearances in court.
Thank you. Ms. Tagupa.
At disbarment, the court had penalized him already in Plus Builders Incorporated and Edgardo Garcia versus Attorney Anastasia Revilla for his willful and intentional falsehood before the court, for misuse of court procedures and processes to delay the execution of a judgment, and for collaborating with non-lawyers in the illegal practice of law. We showed leniency then by reducing his penalty to suspension for about 6 months.
Thank you. Ms. Santos.
Moreover, the court in rendering their decision stated that he is a continuing risk to the public that the legal profession serves. Not even his ardor and overzealousness in defending the interests of his client can save him. Such traits at the expense of everything else, particularly the integrity of the profession and the orderly administration of justice, this court cannot accept nor tolerate.
Thank you. Ms. Tapare.
For the statement of case, on July 8, 2010, Revilla filed a petition for judicial clemency and compassion, praying that his license to practice law be restored based on a humanitarian consideration, but the court en banc resolved to deny the petition for lack of merit. Subsequently, Revilla appealed his case and pleaded the court's mercy, but his prayers were denied by the court, albeit Revilla continued to file appeal before the court and continued to receive negative response from the court.
Thank you. Ms. Calceta.
On On July 18, 2014, the respondent filed a profound appeal for judicial clemency, reiterating his apologies to the court. He stressed that the penalty of disbarment has already taken its toll on his health. He has now become most frail and weak, and he had been diagnosed with chronic kidney disease at stage 5 and undergoing dialysis thrice weekly. He also stressed that in the years that he had been excluded from the practice of law, he devoted his time to Christian and charity pursuits, serving with all humility as a lay minister and a regular lecturer on legal aspect of marriage at St. Peter Church, Quezon City.
Thank you. Mr. Sullano?
The respondent also pleads for clemency, not because he intends to practice law again, but to be made whole, to recover from being shattered, and to finally have peace of mind. He expressed his sincere repentance and deep remorse by taking full responsibility for his misdemeanor. He also prayed that his disbarment be lifted and that he be reinstated as a member of the Philippine Bar. As part of his petition, he submitted a medical abstract evidencing his diagnosis for chronic kidney disease and a certification from St. Peter Parish, Commonwealth Avenue, Quezon City, proving that he and his family are dedicated parishioners.
All right, thank you, presenters. And now the issue of the case is that whether or not Attorney Revilla is qualified for reinstatement in the practice of law. So for the court's ruling, let me call on Ms. Magno.
Thank you so much for that, Sir Michael. So the yield is no, Attorney Revilla is no longer qualified. So membership in the bar in a privilege burden with conditions. So it is not a natural, absolute, or constitutional right granted to everyone who demands it, but rather a special privilege granted and continued only to those who demonstrate special fitness, intellectual attainment, and in a moral character. So the same reasoning applies to reinstatement of a disbarred lawyer. So when exercising its inherent power to grant reinstatement, the court should see to it that only those who establish their present moral fitness and knowledge of the law will be readmitted to the bar. Thus, though the doors to the practice of law are never permanently closed on a disbarred attorney, so the court owes a duty to the legal profession as well as to the general public to ensure that if the doors are opened, it is done so only as a matter of justice.
Thank you. Ms. Santos?
Basic inquiry in a petition for reinstatement to the practice of law is whether the lawyer has sufficiently rehabilitated himself or herself in conduct and character. Whether the applicant shall be reinstated in the role of attorneys rests on a great extent of the sound discretion of the court. The lawyer has to demonstrate and prove by clear and convincing evidence that he or she is again worthy of membership of the bar. The court will take into consideration his or her character and standing prior to the disbarment, the nature and character of the charges for which he or she was disbarred, his or her conduct subsequent to the disbarment, and the time that has elapsed in between the disbarment and the application for reinstatement.
Thank you. Ms. Yanong?
In the present case, the Supreme Court was not fully convinced that a passage of more than 4 years is sufficient to enable respondent Revilla to reflect and to realize his professional transgressions. The Supreme Court emphasized that it was the second time that respondent was accused and was found guilty of gross misconduct. Respondent in an earlier case of Plus Builders Incorporated versus Attorney Anastasio E. Revilla Jr. was likewise found guilty of gross misconduct for committing willful and intentional falsehood before the court, misusing court procedure and processes to delay the execution of a judgment, and collaborating with non-lawyers in the illegal practice of law. mostly the same grounds on which the decision dated December 4, 2009 was based. So in Plus Builders, the Supreme Court granted the respondent's motion for consideration and his penalty was reduced of suspension from the practice of law from 2 years to 6 months out of compassion to the respondent.
Thank you. Mr. Centillas?
Thank you for that, Sir Mike. So, in addition to that, the Supreme Court also added that considering the respondent's earlier disbarment case, which was reduced the penalty imposed due to clemency, and another disbarment case against him, which is still pending for review by the court, the Supreme Court are not fully and convincingly satisfied that the respondent has already reformed, and the period of 5 years is likewise not considerably long, considering the nature and perversity of the respondent's misdeeds. Supreme Court says that they did not believe that it is still early for the court to consider the respondent's reinstatement.
Thank you, Mr. Centillas. Ms. Derecho?
Thank you, Sir Mike. Furthermore, we are not persuaded by the respondent's sincerity in acknowledging his guilt. While he expressly stated in his appeal that he had taken full responsibility of his misdemeanor, his previous inclination to cast the blame to other individuals, to invoke the denial, and to make alibi for his wrongdoing, contradicted his assertion. The respondent also failed to submit proof satisfactorily showing his contrition. He failed to establish by clear and convincing evidence that he is again worthy of membership in the legal profession. We thus entertain serious doubts that the respondent had completely reformed.
Thank you. Mr. Musa?
As a final word, while the court sympathizes with the respondent's unfortunate physical condition, the court stressed that considering his application for reinstatement to the practice of law, the duty of the court is to determine whether he has established moral reformation and rehabilitation, disregarding its feeling of sympathy or pity. Purely at this point, this requirement was not met. Until such time when the respondent can demonstrate to the court that he is completely rehabilitated himself and deserves to resume his membership in the bar, our decision to the court's decision to disbar him from the practice of law stands. The dispositive portion of the resolution reads, wherefore the profound appeal of the judicial clemency filed by Antonio Anastasio E. Revilla Jr. is hereby denied.
Thank you, presenters. So that ends our report. I hope you learned something from our discussion. And in behalf of my team, I'd like to thank you for tuning in. And please like, comment, and share down below. Happy holidays, everyone.